You might think your inheritance is safely protected simply because it is in a trust, but in California, if your child gets divorced, sued, or files for a bankruptcy, that inheritance can still be taken, sometimes within weeks, if the trust isn't drafted correctly. Hi, I'm Ali Talai, a California trust and asset protection attorney, and after reviewing more than 3,000 trusts over the past decade, I can tell you that most parents assume their trust protects their children, but nearly 90% of the trusts I review fail to do so. In this video, I will explain how to structure an inheritance trust so it stays protected from divorcing spouses, lawsuit plaintiffs, bankruptcy trustees, and even future remarriages, and how to fix the common hidden flaws that I see over and over again in California estate plans. Imagine spending your whole life building something meaningful and wanting to pass it to your children. Let me tell you what most parents tell me. They tell me that they want to do something so that when they pass away, they can have their estate set up in such a way that their assets passes and goes to their family, stays within the family. But in California, if your child inherits money or property directly, meaning that the assets transfers into their personal name, then that inheritance becomes exposed the moment it lands in their hand. Unfortunately, I see this constantly. A child inherits money and within weeks a divorce lawyer freezes their account, or the child gets into some sort of a car accident and now all of a sudden the plaintiff's attorney attaches a judgment on the properties that the child inherited. Or if they file bankruptcy, if the beneficiary filed bankruptcy, the trustee can claim inherited assets to pay creditors. And if your child passes away, their spouse can possibly inherit everything and then leave it to anyone they want. Sometimes that person could be someone that you've never met. Parents intend their inheritance to stay in their family bloodline, but the default way most trusts are drafted makes that outcome extremely unlikely. We live in California, and California's law adds another layer of complexity. We are a community property state, right? Which means if your child commingles inherited assets by placing them into a joint account, adding the spouse to the title of the property, or investing together, those assets can lose their separate property status. Usually, once commingled, they can be treated as marital property in a divorce proceeding or become reachable by a spouse's creditor. I see responsible, financially stable children make these innocent mistakes all the time. It's usually not intentional. It is simply easy to do. And once it happens, it is not easy to uncommingle. That is why proper trust design matters so much in California. The most effective way to protect inherited wealth from your children's creditor is to leave the inheritance inside something called an inheritance trust, which is also known as a subtrust or a form of a spendthrift trust. Instead of giving assets directly to your children, your trust will include an inheritance trust. Inside of it, right when you're creating the trust, that inheritance trust will be for each beneficiary. They sort of sit there idle. They become effective when you pass away. Your child can become the trustee at a certain age, and also your child will be the beneficiary of their own trust, meaning they have access, control, and decision-making power, but the inheritance does not sit in their personal name. This distinction is critical because the assets remain inside the trust. They are generally protected from lawsuits, divorce claims, bankruptcy proceeding, and even future spouses. If your child passes away, the assets do not automatically go to their spouse. Instead, you control where they go, whether that's to your grandchildren or back to your other children. This is the only way to truly guarantee that what you leave behind stays in your family bloodline. In my estate planning webinar, which you can, if you like to, you can register on my website, talailaw.com, under the events page, and I will place a link down in the description that could take you to the page that you could register for the webinar. I talk about how I have reviewed so many trusts, and so many of these trusts that I have reviewed don't include any of these provisions. And these are trusts that have been drafted by other estate planning attorneys, and the trust is really simple and just makes distribution outright to the children, and there is no asset protection succession planning in place for the beneficiary. I recently reviewed a trust where a mother left a substantial amount of cash to her son. 2 months after her passing, his ex-wife's attorney froze the account. This money that was intended to be used for the son to purchase a home ended up paying legal fees. Had the asset been placed inside of an inheritance trust, no attorney in that divorce case would have been able to touch it. Even if your child is responsible and financially sophisticated, none of us can predict the future. Your child might get sued many years from now due to a business issue or a real estate deal gone wrong or a malpractice claim or a car accident. They might later go through a divorce or bankruptcy. Life is long and inheritance often lasts for decades. An inheritance should not disappear because of something that happens 20 years down the line. A properly drafted inheritance trust acts as a permanent firewall against those unexpected events. Choosing the right structure inside the trust also affects taxes. In my estate planning webinar, I explained the importance of drafting these sub-trusts as a 678 trust so the inheritance avoids the negative income tax consequences and it is not subject to the higher trust tax brackets. And this is where my background in tax law becomes important because many poorly drafted trusts trigger unintended tax liabilities that could have been completely avoided with proper planning. A well-drafted inheritance trust gives your child credit protection, divorce protection, and remarriage protection while also allowing them to enjoy the income tax benefits of owning the property. Parents don't create inheritance trusts because they don't trust their children. They create them because they want a plan that cannot be undone by life's unpredictability. Leaving assets outright is the most dangerous thing you can do for your children in California. Leaving assets inside a properly drafted inheritance trust, on the other hand, is the safest and the most reliable way to ensure that your life's work stays within your family. It is protected for as long as possible. If you found this video helpful, be sure to watch my next video, 5 rental property mistakes that could cost you everything in California, where I will explain how to structure ownership, maintain proper records, protect yourself from liability, and preserve your equity, especially if you own or plan to own rental property or real estate in the state of California. It is essential viewing for anyone with investment properties in California. I look forward to seeing you over there.